Morning. Today we are going to analyze one problem question on registered title under LRA 2002. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Let's start with the problem question. Kate is a registered owner of the consort house which she purchased with her partner William. William contributed 40% and Kate the balance of the purchase price. Kate granted a lease of the stable block behind the consort house to Annie for 7 years. Annie uses it for her horse training business. Harry has an easement over the part of the grounds belonging to consort house, giving him access to the lake from his neighboring property. Harry has not used the easement for some considerable time since he and Kate fell out. Last year, Kate granted Megan a 5-year option to purchase a consort house for 2 million. Last month, Kate sold consort house to Edward for 10 million while William, an army captain, was abroad on active military duty. At the time, Megan was staying in the East Wing at Consort House while the roof of her cottage was being completely retiled. Edward is now the registered owner of the Consort House. We have to advise Edward we have to advise Edward if the Williams legal portion differ if the title to the land was unregistered and the transaction were carried out solely subject to the rules of the unregistered title. First one is the overarching and beneficial interest. Under the Law of Property Act 1925, LPA 1925, specifically the Section 2 on the 27.2, a purchaser of a legal estate takes free from equitable interest if they pay the purchase money to at least two trustees. In our case, a Kate is a sole legal owner, and William's interest is likely equitable since he contributed to the purchase price. As per the Williams and Glenbanks versus Boland case, established that a beneficial interest is protected in a way that cannot be overridden by a purchaser without notice. Since William contributed 40% but is not a registered owner, he may have a beneficial interest that would not be overreached, making him a necessary party in any sale. Ownership and contribution. Kate is the registered owner of the concert house. William contributed 40% to the purchase, but is not a registered proprietor. Under the case which we have seen just now, under William's case, a spouse can assert a beneficial interest even if they are not the registered owner. So the case emphasized that the equitable interest can arise from contributions to the purchase price, especially within a domestic setting. Second one is the lease to Annie. A Kate granted Annie a 7-year lease for the stable block. Under Section 272D of the LRA 2002, leases longer than 7 years must be registered to bind a purchaser. However, since Annie's lease is for exactly 7 years, it does not require a registration but is protected as an overriding interest under Schedule 3, Para 1 of LRA 2002. This means that Edward must respect Annie's lease despite not being registered, since it is a legal lease for a term for less than 7 years. What about the easement for Harry? Harry has an easement over the part of the grounds, but he has not used it recently. Under Schedule 3, Para 3 of LRA 2002, an easement can still bind a purchaser if it has been exercised within 12 months prior to the disposition, or if it was known or obvious. Given that Harry has not used it for some time, there is a risk that it may not bind Edward unless he had actual notice of it or it was visible. Harry's easement is a legal easement which typically binds the land regardless of the registration under 27.2D of LRA 2002. Since Harry has not used the easement for some time, it could be argued that its enforcement may be challenged. But the easement still exists as a legal right unless formally extinguished. Option to purchase for Megan. Kate granted Megan a 5-year option to purchase the concert house. Under Section 33 of the LRA 2002, options that are not registered may not bind Edward unless they are protected by a notice on the register. Since Kate sold the concert house to Edward, Megan's option may not be enforceable unless it can be argued that it constitutes an overriding interest due to the actual occupation, as she is staying at the concert house. What are the options to purchase for Megan? The Megan option to purchase a significant interest. Under the section LRA, section 40 of LRA 2002, an option to purchase is not automatically registered but can be protected by a notice on the register. If Megan did not protect her option, Edward, as a bona fide purchaser for value, may not be bound by it. As per the case in Abbey National BS versus Kane in 1991, the court held that a purchaser is bound by interests that override the registration only if they are protected or visible. What is William's position? William, while not registered owner, may have a beneficial interest in the property due to his financial contribution. If the property was registered, Abbey National BS versus Kane supports a view that his interest could be recognized if he is not on the title. The Family Law Act 1996 could also provide grounds for Williams to claim rights as cohabitant, depending on the circumstances. If it is a registered title, Edward should consider the risk of William's beneficial interest potentially affecting his ownership and should investigate Megan's option to purchase. If it is unregistered title, Edward should have more secure option, but he still needs to ensure that due diligence is conducted thoroughly to avoid any unexpected claims. Next one is William's interest. Under the Land Registration Act 2002, LRA 2002, a Kate is a registered proprietor of concert house. However, William may have an equitable interest in the property due to his financial contribution. As per the case Williams versus Bank versus Boland, the House of Lords established that a spouse beneficial interest in a property can be protected even if it is not registered. The principle is relevant as William may claim a beneficial interest. As per the Family Law Act 1996, this act provides for the protection of the interest in the home for the spouses and the civil partners, further supporting the Williams' claim to an interest. If the title was unregistered, William's position would be less secure because he would need to prove a good root of title or a constructive test, as established in Choker versus Choker in 1984, where it was held that a beneficial interest could be recognized based on the contributions and occupation. Next one is advice to Edward. William's position. While Edward is a registered owner, William's equitable interest could still be enforceable if William can demonstrate that his contribution establishes an equitable interest. He may be able to claim a share in the proceeds of the sale or the property itself, especially since he was not notified of the sale. What about the Megan's position? If the Megan was not registered, it would be likely not to be enforceable against Edward. However, if she was in occupation, as she was staying in the East Wing, this could be argued under the paragraph 3 of Schedule 3 of LRA 2002 as an interest that binds the purchaser due to actual occupation. What about Harry's easement? Edward needs to respect Harry's easement as it is a legal right attached to the land. If the title to the concert house was unregistered, the analysis would shift significantly. William's equitable interest would require registration to protect it against the subsequent purchases. If the title is unregistered, Edward would have no obligation to investigate the Williams claim as per section 27.2 of LP 1925. However, if Williams' interest was equitable and he could establish a claim under the doctrine of notice, it might still bind Edward if he had actual knowledge of William's contributions. Land Charges Registration. Under the Land Charges Act 1972, if William did not register his interest as a land charge, it could be void against Edward as a purchaser for money or money's worth. Legal versus equitable interest. Without registration, the enforceability of William's beneficial interest would hinge on the doctrine of notice as established in Counsey versus Counsey. Edward would need to have actual constructive or imputed notice of William's interest to be bound by it. Impact of absence. William's absence due to military service could affect the application of the constructive notice. If Edward had no knowledge of William's interest at the time of the transaction, he may not be bound by it, as per the principles in Kingsnorth versus Tizat. If the title was unregistered, the root of the title, Edward would need to ensure that Kate had a good root of title. He would need to investigate the title thoroughly, which involves checking the previous conveyances to confirm William's interest. Under the unregistered title, William's claim may be stronger as he could assert a claim based on the contributions without the need for registration, as long as he can establish a clear chain of title. Cases like Choker versus Choker highlights how contribution can lead to equitable interest. Edward would have to deal with any unregistered interest directly and potentially face claims from Williams or others if their rights were not properly protected or disclosed during the conveyancing process. Let's conclude. A title to Concert House. Edward is the registered owner. He should have a priority over unprotected interest. However, he must respect Annie's lease and Harry's easement. Megan's option. Edward may be able to argue that Megan's option is not enforceable due to the lack of protection on the register unless he had a notice of her claim. A William's interest. Edward should be cautious regarding William's potential claim to a beneficial interest. If William takes action, he may invoke the principle established in Boland to argue that he has a claim to a share of the property. If the title were unregistered, the Williams position would be much weaker, requiring him to establish an equitable interest through the doctrine of constructive trust or other means specified in cases such as Thompson versus Fye. In summary, Edward is advised to conduct diligence regarding the existing interest, particularly those of William and Meghan, and to ensure he respects the right of Annie and Harry. If it is a registered title, Edward is likely protected against William's equitable interest due to his status as a bona fide purchaser. He should ensure that no other equitable interest like Megan's option or the easement affect his ownership. If it is unregistered title, if the title, the Edward should investigate any claims by William more carefully as his failure to register could affect his ability to assert his interest against Edward. Thank you.